This is case number 22 CV 602, Peter J. Ross versus Matthew A. Berdyck. Mr. Ross had filed a petition requesting a civil stalking protection order against Mr. Berdyck. The matter is set before me today for full evidentiary hearing. Mr. Berdyck is presently, I believe, in California, and so we've made arrangements for him to appear by Zoom. Last night, I believe, Mr. Berdyck filed a motion to continue today's hearing date. So, Mr. Berdyck, if you want to put your reasons why you're requesting a continuance, please.
I had hoped that we could resolve this case today. I've actually had quite a few hearings over my son over the years. Mr. Ross, in his filing, included that I made over 150 videos about him, which of course I'm allowed to do. I have freedom of speech. That's not something that one would file a civil stalking protection order over. However, those videos, as I can show, via Mr. Ross's own statements at his public Q&As that he does about me. He's made a movie about me and he does Q&As. He stated these videos are made in response to him. Now, these videos were made in response to the content of his Twitter account and his social media account for the movie Social Media Monster, and he has deleted them.
Oh, okay. That's what I was saying. So you're saying that he deleted these videos?
Yes, there's no way for me to talk about the context of his complaint since he's deleted all of the evidence I would need to show what I was making videos about.
Okay, 1 second.
He did this I want to point out he did this after this case was already going after the 10th. He deleted his social media like 2 weeks ago.
Okay, sir, but in terms of asking for continuance, what do you intend to do if you get a continuance?
I need to take the time to hire an attorney, but I also need to engage in discovery and obtain all of his evidence that he intends to use, witness lists, et cetera, et cetera. I need time to build a case. This is very complex. Now that Mr. Ross has deleted all of the evidence, it's made it even harder.
Do you intend to hire an attorney?
I'm trying to.
Okay, because I know you live out of state, but you would need to find somebody that's licensed to practice in Ohio.
I'm aware of that.
Okay, I know you're aware of that, but I'm just saying, but are you making efforts to do that?
Yes, I am trying to. Unfortunately, if you look at the filing that Mr. Ross made, the motion for service via email, you'll see that he exposed the name of my business. And since I engage in activism and journalism and I have security issues in my life as a public figure, I've had to shut down my business and it's caused me financial harm. So I am desperately trying. I am working a job in a warehouse unloading trucks to earn the money to be able to hire an attorney.
I understand. My question is, though, I just want to make sure you were making efforts to do that because...
Yes, I'm trying to. I'm just stating that I'm financially struggling right now due to the actions of Mr. Ross.
All right, Mr. Ross, do you have a position on his request for continuance today?
Yes, I'd like to submit this. He's been aware very early on. He had made this public tweet on March 10th, the date of the last hearing, saying, "Things did not go well in court today for Peter. He was slapped down once again, no matter how hard he tried to scam. The court is making Peter follow the rules, and this makes him really angry."
This was in response to his own
Okay, let him talk. Let him talk. He didn't interrupt you. We're going to let him speak too, okay?
Oh, he's been interrupting me for 10 years.
Sir, okay, but we're in this courtroom now, and we're going to let each other speak without interrupting each other.
He's lying to you right now.
Sir, okay, so you're going to oppose his request because what I'm hearing you say is that he's known about this for some time and could get, okay.
My response to what Mr. Ross just said very specifically is that tweet was in response to one of his posts after the hearing, and he deleted it. And I can't show you that because he deleted it.
Okay.
I didn't know about the hearing.
Your Honor, that's absolutely false.
I have a copy of the post.
Okay, we could go back and forth all day long.
I have a copy of his post.
I get it that I think you both...
But I can't show it to you because he deleted it.
Okay, so here's the problem, sir? The law says service has to be perfected in accordance with the rules, and that a party being aware of a lawsuit, which this isn't truly a lawsuit, but it's equivalent to somebody just being aware of a lawsuit, doesn't really matter if they haven't been served yet. And sometimes there's an element of gamesmanship. I'm not saying you're doing that, but I'm saying that even when somebody's playing games, when service hasn't been perfected yet, it's as if the court doesn't have jurisdiction over them yet. What happened here was we do now have proof of service March 17th, so we do have proper jurisdiction.
So he is considered served at this time?
He's known this for the last month that I've been served.
No,
I said this already.
I'm not going to get an extensive discussion about service, but we did have a problem with service because of the original certified mail was signed for and came back, didn't count anymore. This is second certified mail was accepted, so we do have personal jurisdiction. Okay.
Excuse me.
No.
Wait a minute. Who accepted service on my behalf out of a piece of mail?
I don't know because of the way it's scribbled.
No, I would say Mr. Ross forged that. That's not true because I don't
Sir,
receive
okay,
mail
you can
anywhere.
say a lot of things. Right now, I don't have
I
any
need you to
proof of that.
present me with a copy of that letter you're stating you have because I say it's fraudulent.
Okay, and then if you hire an attorney, you can challenge service. But right now, the court has proof of service in the record.
Well,
But
I've
it didn't
asked for a
happen. Listen,
continuance
sir, if you
already,
would give me a chance to
so-
speak, things would go a lot better for you. Okay.
I know.
The
I'm just.
service-
I
right,
don't really care how things
okay,
go.
right
I'm tired
now-
of being stalked by this man.
Here's the.
This man is a stalker.
Okay, sir. Like I said, it's going to go a lot better for you if you let me speak. At this point, I do have proof of service. It didn't happen till mid-March. Under the statute, it says that the court should grant a reasonable continuance request, and one of the bases is if somebody says they intend to hire an attorney. My concern for you, sir, I'm not shocked that you're coming and objecting to this. I get it. I get both sides, meaning his request to continuance. My concern is looking out for both parties. I've been doing this job for 23 years. If somebody at the first hearing date, which this is truly the first hearing date since he's been served.
Okay.
If somebody asks for a continuance at the first hearing date and the court says no, if you prevail, then he's got good grounds for an appeal because they're going to say this was the first hearing date, he asked for a continuance and you should have granted it. So my concern though is that I don't want to grant a continuance request and then a month later there's another reason why somebody needs a continuance. We're not going to do that. So we're going to pick a new date. I'll start at 11 o'clock. That way it's a more reasonable hour for you. And the hearing will go forward on the new date, okay, Mr. Berdyck? If you retain an attorney, then they're going to know how to properly ask for discovery. I can't give either of you legal advice. So my concern is if you don't hire an attorney, it's your obligation to properly ask him for discovery.
I know how, and I have properly asked him.
No,
and I know
don't
how
believe
to
you.
do this,
I
and
don't
he's
know
not
if you have or
complying.
haven't, but I can't give you legal advice. But the first step is you have to file a motion with the court asking for leave to conduct
I'm aware
discovery.
of
And
that.
I know
That's
I
why
haven't
asked
gotten
for
that
a
motion.
continuance. I have strep throat right now. I would really like to go back to bed.
Okay, sir.
I know
I'm
how
going
to
to note
do
your
this.
objection
I
for the
don't need-
record fairly, but you understand my ruling that I'm going to have to grant continuance. I know you have a lot of witnesses here. At the next court date, we may actually have them log in only when you need them if they can be on standby because it's just, we don't have the best court.
I understand.
But we'll figure it out. We will figure it out because, but sir, at the end of the day, you need to take immediate steps now to try to get an attorney. Okay? If not, then at the next court date, whether you have counsel or not, we're going to go forward.
I would like to speak for a second. I know how to do motions for discovery. I have made a good faith request to Mr. Ross for discovery and witness lists. He has refused to respond. So now I need to file a motion for discovery. I had hoped that he would try to just give me what we need so we can move forward, but he's being stubborn.
Your Honor?
So now what I need to do is file a motion for discovery to be able to do this.
Yes.
I know how to do it.
I know.
just need the time.
Or if you're really
And Mr.
serious
Ross
about
needs to
getting an attorney,
cooperate.
then do that, please. Yes, Mr. Ross?
I do want to state that he has made these objections on his Twitter live videos. I contacted this court a week and a half ago.
He's aware.
And offered to upload all of this to a Google Drive ahead of time. And I was told that we would only
You're
be
saying the
presenting
court
here.
blocked this.
If you want, is there a way? I'm not very technologically savvy. You guys are way ahead of that than I am. Are you telling me right now that you're willing to upload a Google Drive that he can access?
Yes.
Because I don't want to
And
review
why didn't he
this.
do that 3 days ago so we could handle the case
What
today?
he's saying is that he was trying to make arrangements to
No,
do
he
that,
wasn't. All I
okay?
got
And
was harassing emails.
it's not his fault, it's the court's fault, because I don't think the court understood.
Oh, no,
I-
no, it's his fault.
No,
All I got
no,
was
it's not.
harassing emails from
How
him
do
in
you,
response.
I am not technologically savvy, so what are you telling me you can do?
I can upload all the documents and videos to a drive folder that's accessible to anybody who gets it.
Okay,
I
and then
just-
you can give the court that information, and then we can pass it on to him?
Yes, I want
Okay,
no
we will-
Here's a-
contact with him
here's a
whatsoever.
second-
That's how we'll
request.
do it then.
Okay.
Okay, so
Then
at
here's
least,
something important.
what?
Here's something important. If Mr. Ross is going to upload videos, they need to be the native videos and non-edited by him.
Okay, we're not gonna
in
get
full
into the
context.
nitty gritty. He is going to upload what he intends to introduce as evidence.
Yeah, he's going to upload
So-
edited videos.
And,
I already
and that's
know. He's
something
been
we'll
doing
fight
this for
about.
10 years.
That goes to the weight of the evidence. That's a fair point you can raise at the
He's
hearing.
been doing this for 10 years.
Okay. Sir, what I'm gonna do is,
Stalking me and my children for 10
okay,
years.
this isn't helping anybody. What I'm gonna do is I'm gonna let Mr. Ross leave the courtroom. I'm gonna ask you to wait a couple minutes. I'm gonna get a new date from Mary Ann, and then I'm gonna come back and give you the new date, okay? Now, we were thinking of a Wednesday or Thursday. It's April 14th. The rest of April and the first half of May are pretty much booked. So we are considering the second half of May or June for a new date.
June would be better. That would give me more time to hire
Well,
an attorney.
I was gonna say, if we did early June, by then you'd know if you're gonna have an attorney or not. Yes, sir.
That's fine, but Thursdays are definitely better.
Thursdays are better. Okay, so we can,
Oh, I see. Thursdays are better for Mr. Ross. 6 in the morning's okay for me with strep
well,
throat.
this was the first, okay, no comment, but that
My
had,
address
Mr. Ross.
is California. Why
Mr.
was
Ross
this
had no
hearing?
control over what the court did today.
My address
and
is
I'm-
California. Why was this hearing scheduled at 6 in the morning to give me a
Because
disadvantage?
this is an Ohio court, sir. So
Well,
I will,
unfortunately, my
and I already
address on
told
the
you,
filing
I
is
started
6 in the
off when I
morning.
said I was gonna grant a continuance, I said we were going to reschedule for 11 o'clock. So we are trying to accommodate you. That's it. That's what we're gonna do. So, we're gonna look at
Can you ask
Thursday in
Mr. Ross to
June.
ask his friends to stop harassing me with anonymous Twitter accounts and calling me a faggot over the duration of the case?
Okay, Mr. Ross, I'm gonna excuse you from the courtroom right now, okay? Because all we're gonna do now is get a new date. I'm gonna come back in a minute with a new date, okay?
I filed police reports over Mr. Ross's faggot communications, calling me a faggot and a queer and all of these things. I filed them before he filed this case. That's what
Okay.
this case is about.
Okay.
He's under investigation in the state of California for stalking and
Okay,
harassment
I'm
right
gonna
now.
pause the record.